Hey y'all, welcome to the Petty Details. I'm Jen, this is Justin, and we are Petty Details, and we are subject matter experts in auto property damage claims. Justin consults attorneys, talks to individuals all day long, helps body shops, adjusters, a lot of people. He helps a lot of people, and we help a lot of people as a company. Okay, so I have a question. Who in the hell has the time to sit around and wait for their money for a month, 2 months, 3, however long it takes to get the total loss settled without being able to get a car? You know, I mean, like there are thousands of dollars that they're owed. How are you supposed to sit around and wait for that?
Yeah, I mean,
Tell us.
yeah, it's hard. I mean, because a lot of times there's delays on liability. It depends if it's first party or third party claim, because if you're filing with somebody else's insurance company, you're going to have to wait on that company to call the person, get a statement about what happened, get the police report. So you're talking 2 weeks, before anything happens, that you don't even have a car to deal with. It's if you have a bad enough claim that your car's not drivable. And so in those instances like that, use your own insurance if you have it, and use your own collision coverage. And in that case, there's some things you can do. You can go through that process, use your rental reimbursement. That'll buffer your loss a little bit. You might get your $35 a day that you have coverage for. That'll help you if you need to have a Tesla. It'll just pay towards it. But if you need a certain type of vehicle and you have to have the same kind of car that you had, you might as well rent that type of car and let your rental reimbursement pay you as much as it will. And then that loss of use claim goes against the at-fault party later. All this is to say that you go through your own insurance company and they deem your vehicle a total loss. What are you going to do for 30 days while y'all are trying to negotiate the settlement? They make you an offer and you're like, that's way too low. And they're like, okay, well, fine. What do you want to do about it? Do what you got to do.
Yeah, because a lot of people that are in that situation have already been fighting when we talk to them for 30 days, for just the value for 30 days.
Yeah, by the time they call us, it's like I can't get them to make a fair offer. I've sent them a bunch of comps, and I've sent them a bunch of, I've argued and argued and argued, and I can't get them to do anything.
And da-da-da. Yeah. Mm-hmm.
Right.
So
and a lot of it's because they're dealing with somebody else's company, but some of it's because they're dealing with their own insurance company, and they don't know they have appraisal clause to invoke.
Yeah, the appraisal clause. That's your answer, the appraisal clause. But what can you do with the appraisal clause so you don't have to sit and wait?
So if your insurance company has made an offer to you, then in most states, the statute that in the insurance code is a statute. So in the insurance code, it dictates how they have to pay. So for example, in Texas, it's Texas Insurance Code section 540. You look at that insurance code and it says that you must pay a payment of the claim or part of the claim once you've offered that amount. So when they've offered you a total loss amount, then they're obligated to pay that to you without regard to whether you dispute that amount. That here's the undisputed amount. This is what the insurance company has already agreed that they owe you. They should pay that as what is called the undisputed portion. And so it's real tricky because adjusters don't understand the terminology, because that terminology is used in case law and they don't read it. They don't read case law. And so when you talk about the undisputed portion of a claim, lots of adjusters don't know what that is.
Yeah, I have a statement. So I asked for the undisputed portion, and the adjuster said, no, they can't pay that to me because I invoked the appraisal clause, and they can't pay that to me until afterwards, because what if my settlement is lower than what I've already been offered? That's their threat is, it could be lower if you go through the appraisal clause. It might be lower amount. And it's like, well, it scares them, So that's what I hear a lot.
Yeah, I mean, that's a stretch of the logic involved in appraisal clause. Clearly, they can't reduce their offer. They've already agreed that it's a certain amount. So to say that it's going to go to appraisal and be lower would be ridiculous. No independent appraiser is going to say, well, let's take money away from the person. Even though they were already offered this amount, let's offer less than that. How about that?
Although I did hear there's a company here in Texas that did do that, because I read a review.
Uh-huh. It could happen,
but we would never do that. We would never do that.
That's a real extreme scenario, and so I never.
But it happens. Worst case.
It never happened to us. Not one time.
Look at my glow. I'm glowing. Sorry, I got distracted. So keep going.
Yeah, no, I mean, the undisputed portion, most insurance companies, and just to name one, State Farm sends out a letter when somebody invokes the appraisal clause, that just says exactly what we're saying. Look, we're going to send you the undisputed portion. So I commend them for this. They send out a letter that says
Least.
we're going to pay you the undisputed portion, and if it comes in lower, we're not going to ask you for reimbursement. And so they just alleviate that issue right off the bat, and I like that about it. They do
Yeah.
try to control all the other aspects of it, and they're sneaky sometimes, but
Some of
at
them, yeah,
least,
some of those carriers like to try to have their hands in the process,
yeah.
even though it's independent, you know.
Well, a lot of
And that's
carriers
another
like,
video too, but still.
yeah, well, yeah, we get into the way carriers handle litigation threats. And
Yeah.
so a lot of carriers know that they're going to lose, but they bank on that the person's not going to sue. So they'll do something that's not kosher, if you will, and they hope that it doesn't come back to bite them.
Yeah.
And it's
And it
like,
doesn't a
well,
lot because
it
people will
doesn't
not
all the
fight for
time.
themselves a lot.
It's economical for them to do that. I wrote an article called "The Economic Bully Stick." Go look at it. You know,
Yeah, that's a good one.
I'm
I
fixing
should link
I'm
that
fixing
one.
to update it. Yeah,
Yeah.
and we got to update it because the numbers are off. The inflation has kicked us in the butt over the years since I wrote that article.
Yeah,
Because
it's
I
been
was
a
like, oh
while.
yeah, you can't sue for less than 5,000. Now it's hardly you can't sue for less than 12,000. You know,
Yeah.
and
Yeah.
so it's like
Yeah.
you have to really know how to make yourself a threat, a credible threat. I'll tell that story about the Rottweiler at some point on
Yeah.
another video. Yeah.
Yeah. Well, if you're dealing with an issue like that, or you have a question about undisputed portions, or you've been told that you can't be paid the undisputed portion, you're probably already in the process if that's the case, and you've probably already hired an appraiser. But if you need someone to look at your total loss and tell you if it's worth it to go through that appraisal clause process, you can do that. You can get the undisputed portion. Even if they say that you can't, you can do some things to bring to light that that's not the way it works. And we'll definitely be here to help you with that if you need our help. So we're Petty Details. Thanks for joining us, and we hope to see you on the next video.